Welcome to the Hyperion Commentary Podcast. We have with us today Rodney Chrisman, who's a professor at Liberty University School of Law. He's been there. Have you been there since the beginning, Rodney?
Almost. I've been there 18 years. So I've had every class that's graduated. I had the first class when they were second-year law students. So
Yeah, so been there for a very long time. Rodney has also been a pastor in the past and has done a whole lot of thinking on application of biblical law to our world today. So I'm excited to get to talk to him. And if you have never heard of him, this is a time to hear some good stuff. So Rodney, welcome. Glad to have you here.
Thanks, Rick. It's good to be here.
So I just wanted to talk to you a little bit today about several cases that you have an interest in, but I also wanted to ask the question right up front. Just a few weeks ago, we had Rick Boyer on here, who's another lawyer. It seems like there are a whole lot of lawyers who have Calvinistic Reformed leanings, starting with John Calvin himself. Why do you think we Reformed folks like the law so much?
Yeah, well, Rick is a former student of mine. So I had him as a student at the law school years ago. So good friend of mine as well. Yeah, lawyers are kind of a mixed bag in church history. I agree. John Calvin, trained as a lawyer. Luther trained for a period of time to be a lawyer. But yeah, we've got some other lawyers, and I guess maybe we won't just necessarily name any. You can name them if you want to, but we can probably think of a few more modern American lawyers who are or famous Christians that maybe not. Not in the Reformed camp, and not people I would be quite as proud of. But I think I think lawyers are drawn to maybe a reform view of the law and theology. And I think the systemization probably it tends to attract lawyers thinking systematically about these things. Probably the logical just approach to some issues of theology as well. I think that probably ends up attracting a lot of legal thinkers and lawyers to that approach, to the sort of the Reformed approach in general.
Probably yeah. So. We have a whole lot of lawyers and a whole lot of engineers in our church, so that kind of tracks the systematic thinking. So I wanted to ask you, since you've been teaching at a Christian law school for so long, what are some particular challenges that Christian law schools are facing in our current crazy times culturally, and what can a Christian law school student expect if they want to go into the practice of law today?
Yeah, well, that's a great question. And as these things work, a lot of times in society, often lawyers and doctors, so capturing the professions is a way to try to really capture and impact the culture on these issues. And I would say the biggest challenge, no doubt, is sexual orientation, gender identity, and now these phrases keep changing. It's gender expression now is one of the big phrases on that. And this poses a particular challenge to Christian law schools because of the nature of the way accrediting bodies work. So accrediting bodies are able to expect, and that's the American Bar Association is the accrediting body through the Department of Education. They require certain things. They have these standards that law schools have to live up to. And one of them has to do with non-discrimination policy. And honestly, this is an area that is significantly unsettled. The ABA now expects sexual orientation, gender identity, gender expression. They expect that to all be covered by a law school's non-discrimination policy. And those standards also provide exceptions for schools with a religious mission, which certainly Liberty has, and so it's really not clear yet how that's going to be resolved and worked out. The ABA obviously would like to sort of force compliance on that, and Liberty and other Christian law schools obviously do not want to comply with that. I think it's looking at going to a law school, if you do not choose a law school with a Christian mission, student is really going to face an environment that is very hostile to people who don't want to get on board with the whole, whatever you want to call it, the sexual revolution in its current iteration, this idea of radical self-expression and self-definition. If you don't want to get on board with that, including, preferred pronouns and really celebrating that, you're going to have a real challenge. And I think eventually, even in the practice of law, and I might just say briefly there, Rick, as well, a lot of people who are listening to this podcast might wonder, well, why not just skip the accreditation then? Why even play by those rules? And sometimes you'll hear that the answer being, well, it's basically just the idea we've got to have this federal money. If we don't have the federal money, then so it's really kind of a money thing. And maybe that's true in certain instances, but I can tell you with law schools in particular, the only viable path, with a very few exceptions, the only viable path to become a lawyer in the United States is to go to an ABA accredited law school. And to be an ABA accredited law school, you have to comply with the ABA's requirements. And part of those include participation in federal financial aid. So there's really no choice. It's not a choice between, are we going to participate in these federal systems? It's a question. It's really a choice of, are we going to have an ABA approved law school or not? And if we're not, then our students can't take the bar exam in the vast
That's what I was going to ask. Yeah.
Yep. So, but so those are real challenges. And I think probably the most dire challenge right now for Christian law schools, Christian law students, and indeed Christian lawyers, period.
Are there any test cases sort of making their way through the courts at this point that's going to test that?
I'm sorry.
I was just asking if there are any test cases coming through the courts right now. They're going to sort of test those limits.
Yeah, so not directly with regard to law school accreditation. So not for law schools specifically, and of course not for the regulation of lawyers, which would be through the bar associations. Probably the closest is one of the opinions, or at least related to it, would be a couple of the opinions that the Supreme Court just released. And one of those would, of course, be the 303 creative opinion. So in 303 creative, you had a Christian web designer. So she does a lot of things. She does some videos, some of her own art, writes stories and that type of thing. And she was looking at expanding into doing this Christian web designing for weddings. So there would be a specific website she would design for your wedding. And she's in Colorado. Now, Colorado's already been made famous for the Masterpiece Cake Shop cases. And so she actually, before she went into that area, before she expanded into the wedding area, she sued Colorado to get an opinion that would say that it couldn't be, that their Civil Rights Act, Human Rights Act, almost every state has one, and I think a little more than half the states include sexual orientation, gender identity, include that type of language. She sued them for a declaratory judgment saying that it constitutionally couldn't be applied to her business. So that went all the way to the Supreme Court. That fight did. She lost at the lower court and at the Circuit Court of Appeals. But as you probably heard, she won at the Supreme Court level. And the Supreme Court ruled that, and this was a First Amendment ruling, so it's a freedom of speech ruling. But what that ruling held is that it did exceed Colorado's power. It violated her constitutional rights to require her to prepare these websites for same-sex weddings or for same-sex marriages.
Interesting. So I didn't realize that that was sort of a preemptive lawsuit for a declaratory judgment that she'd made.
Yeah.
I just assumed that, like with the cake case, somebody had come to her wanting her to make a website for them. So this was ahead of time.
Yep.
I don't know the law because I'm not a lawyer. Is that similar? Of course, you have to actually have a judgment in this case, but is it similar to how someone might file an amicus brief to try to get the court, on their side? We're with you on this, or something along those lines?
Yeah, they're probably I guess maybe tangentially related. Now, an amicus brief is actually that's a short for the Latin phrase, which means friend of the court. So you're coming in as a friend of the court. You're not actually a party to the lawsuit in that instance. You're coming in as a friend of the court to advocate for your position. So an injunctive relief or declaratory judgment, what you're doing there is you actually are a real litigant there. And there's a test for that, whether you're entitled to that type of relief. And it requires a number of factors that aren't really important, usually a 3-part test. But the issue is you're actually a litigant there, and you're getting the court to rule in advance. Because what she said, what her argument was, is that if I go forward with this, then Colorado's they're gonna come after me. And just like they did Masterpiece Cake Shop, because that's actually the direction it took, they're going to come after me, and they're going to basically present me. And these are largely the options. You're going to be presented with the option to comply. So that means if you want to come into the public square, and there's a number of these cases that have occurred over the years with differing outcomes. This is the first time the U.S. Supreme Court has clearly ruled on it. But if you want to come into the public square, if you want to do business with the public at all, then you need to check your deeply, sincerely held religious beliefs at the door, and you need to comply with whatever rules we tell you to comply with. So, example in this case would be you got to prepare a website for anybody who wants to come in. Same-sex wedding, it doesn't matter. You've got to do that. Another option would be you're going to suffer fines. I mean, it's Orwellian. One of the things they'll do instead is, in addition to fines, I guess not instead, in addition to fines, they actually have these, I would call them re-education. You can go to training to learn how to be more inclusive and to see the error of your ways. So that, you can check it at the door, you can suffer the consequences, whatever that's going to be. You're of course free to leave that profession, so you can stop practicing your profession. Now, this one's not mentioned at the Supreme Court level, but the other one in other states, the New Mexico Supreme Court, for example, years ago in a lane photography, which was a different case that did not go to the Supreme Court. In that case, the court said, I usually say banishment. You can be banished. Now, they didn't use the word banishment, but what they did say is you can move to another state. So if your state has this law, you can move away. So you're basically left with the choice of keeping quiet, leaving your profession, whatever it is you're wanting to do, or banishment. You've got to leave and go somewhere else. And they specifically, actually, I mean, it was stipulated that the purpose of this law in Colorado is to do away with speech that they don't like on this topic.
Wow.
They want to get rid of these ideas. So it's pretty remarkable, really. And that relates to law schools, because and really other schools that are accredited, and all kinds of other businesses, I think potentially even churches. It's testing how the Supreme Court is going to balance, on the one hand, our constitutional rights over against these, what we sometimes people call civil rights or human rights. It's the right to say, if you are offering services in the public, you can't exclude me for any reason. You have to offer them to me as well.
Right. Well, so that could have major ramifications all across the board then, it sounds like.
Yep.
just from that.
Yeah, and in this one, it came out the right way. At least I'm actually really happy with this Supreme Court term. Now this, I guess, given that this is related to copper, I could tell you what I would rather maybe it be, because I think a lot of times the problem is the government is doing things that are far outside of its jurisdiction anyway. And it would be better if the government just got out of that altogether. Right. But since that's not likely in the near future, you know, I'm largely happy with a number of these opinions. And in this one in particular, I'm happy that they said there's at least a free speech right to refuse service. Now, what concerns me, or maybe what's left open in that, is what about areas that don't involve speech? So let's say instead of, you know, you're preparing, you know, she's clearly preparing things that the court says this is pure speech. What about instead if you are, let's say, just a wedding venue, and you have a place, let's say you've got you buy an old farm, you know, out in the Good area, you fix the farm up and you're going to host weddings there.
This sounds oddly specific.
I know, yeah, that's because I know so many people who've done that. And I know many of those that exist, and they don't want to, you know, they don't want, it would violate their deeply, sincerely held religious beliefs to have a same-sex wedding there. You know, it's an open question. Does that involve speech? I might make an argument that it does, but so there's that. Then even so, let's say we move beyond the speech. Would I just have on you know a establishment clause, free exercise of religion grounds, the ability to say I should be free to refuse that type of ceremony there? And that's an open question. I mean, that's left open, but I can tell you that doesn't look as strong to a lot of people, me included, as if you can tie it to speech. If you can tie it to speech, you're probably going to have a greater likelihood of success.
So it seems like with this particular Supreme Court, though, things have been going really well.
Yeah.
Last June, we had the overturn of Roe v. Wade, and this June we had several of these cases that came out good in ways we like. It's almost like, you know, Clarence Thomas's Santa Claus, and we're getting Christmas in June every year. You know, who knows what we'll get next year.
Very true.
So would you like to talk about, while we have time, any of these other cases that have come through?
Yeah, absolutely. So a few other big cases that I had some interest in and looked at. Probably a lot of people did. So one of those was Biden v. Nebraska. So that is, you might say, is the student loan forgiveness plan case. So probably everybody knows now the Secretary of Education, at of course the Biden administration's direction, adopted this student plan for student loan forgiveness. There were various estimates of, you know, excuse me, what that would actually end up costing. By the time it's got to the Supreme Court, at least based on the people who had applied for forgiveness and looked like they qualified, the Supreme Court was saying that this plan would cost about $430 billion. So almost $500 billion. And this is something, of course, that the Democrats have been unable to push through Congress. And this is something that Biden had made as a campaign promise. They've been unable to push it through Congress. And so they turned to the administrative agencies. So this is really an administrative state case. And I think the administrative state, the regulatory state, is one of the biggest threats to our liberties that exist. Really, you know, even the case we're talking about with 303 Creative, a lot of times these are administrative agencies. Masterpiece Cake Shop involved an administrative agency in Colorado. So these administrative agencies have such broad, unchecked power. And this one, I mean, this one was stupendously big. $430 billion is an astronomical amount of money.
Right.
And so the Supreme Court ended up taking this case. A lot of people were afraid it would fail on standing. It's basically the idea you have to have a real controversy. So if you don't have a real controversy, courts don't just decide opinions just to tell you what the law is. Our system is an adversarial system. We want a real controversy going on with parties on both sides who are both arguing, and we think that's the best way to arrive at the truth. So courts don't make advisory opinions, is what they usually say. We don't just advise you on what the law is. But they overcame the standing issue in part because Missouri had a state corporation that administered some of these loans. And so by those loans being forgiven, they had suffered a harm because they weren't going to get the fees from administering it. So that was really the kind of the hook that got the argument there, but the argument was about the scope of the authority of the executive branch and specifically these administrative agencies. Yeah. And that opinion turned out fantastic. Now, this would be another example. I don't think the federal government should be in the business of making student loans, period. I don't see where biblically, the government has the authority to run student lending programs or, anything like that. I don't see biblically where you find any authority or jurisdiction for the government to do that, but that's not going away anytime soon. So in light of that, I mean, it's a great victory for the Supreme Court to tell the Secretary of Education, you don't have, and they did so really unequivocally, that you don't have this type of authority to enact a program like this. That has to go through Congress. Now that was a 6-3 decision, so there was the liberal justices dissented from that. They would have let this go forward. But yeah, great. I mean, came out the right way.
Yeah.
Exactly what we would want. Again, if we can't get, a perfect biblical republic.
Exactly. I think this is one of the reasons we need Christians in the law, because I've met some guys, they read a little Rushdoony, they get into theonomy, and they have this perfect system built up in their head where if we could refound America today and they alone by themselves got to write every document, we would have a perfect system.
Yeah.
But then they have nowhere to go when it comes to, okay, but here's where we are. What can we do right now practically? We're not going to overthrow the government. We're not going to, we have what we have. What do we do? So I think this is good stuff here.
Yeah, I completely agree with you on that, Rick. And we know each other well, are good friends. I'm a Rushdoony fan. I'm a Bonson fan, but I think you're exactly right that, and it really shows up in a few different ways. I mean, one way that it shows up is this idea that we've sort of got to have an all or nothing. So if we can't eliminate the Department of Education, then nothing is a victory. But that's typically just, I tend to think of it as sort of like the kingdom of God, period. It's leaven and it works through the lump. And we should really be content to see some of these things work out over time and be able to celebrate God's goodness to us on the way there. To take the Dobbs opinion, I would have loved for the Supreme Court to have declared that there's a right to life for the unborn.
Right. Yeah.
Therefore, no abortions, that because that's depriving the unborn of the right to life. But in hoping for that and not getting it, okay, I understand. We knew we weren't going to get that, but there's still a great victory there. And so I'm content to see some of these things unfold over time.
Right. And I did talk to a couple of sort of really hardcore abortion abolitionists who were not excited about that decision. And I'm thinking, are you kidding me? This is one of the greatest things that's happened in 40 years, right? 50 years.
I mean, I honestly thought we'd never see it. Exactly. I really did. I thought we would never see this. And so I agree. And I understand the desire sort of for complete victory. I really do. But I think we should thank the Lord for these steps along the way of, we didn't get in this mess overnight, and we're probably not going to get out of it that way. That's just typically not the way these occur. And I think also just on the the comment you made earlier about, we think if we could sit down and write it out ourselves anew, we would think of everything, we would get it all exactly right. But I am reminded of the power, and obviously this is coming from a lawyer's perspective. I've dedicated my life in a lot of ways to being a minister of justice, to try to see change in the legal system. But I'm reminded, that what's going to triumph is the gospel.
Right.
And just getting a perfect legal system, assuming I knew what that was and I could sit down and write it, that would not work. And I know that for sure for this reason. Presumably, the Israelites had a perfect legal system.
Right.
God gave it to them, right? I mean, he gave them this legal system, but because their hearts were hard, that legal system doesn't work. Now, that doesn't diminish the importance of godly laws, justice. I mean, part of Christ's mission is to spread justice over the earth, but it does sort of give us an ordering principle to say, if we are a rebellious, wicked people, even laws perfectly geared to us will not save us. That won't work. So, and there's a synergy there. The law's didactic. It teaches. So I'm not saying, obviously I've given my life to this. I don't think it's unimportant, but I just think that, the power of the gospel has to work through to make a people who are willing to accept righteous and godly laws. Yeah.
Right. And that civil use of the law to restrain evil is important.
Absolutely.
But it doesn't eliminate evil. It just holds it back.
Correct.
It's still there, and imperfect men are administering it. So
absolutely. Yeah.
Great.
Yeah.
Well, Rodney, we are about 5 minutes till we get to the end of our time together here. Do you want to talk about Groff versus DeJoy? Because that was kind of an exciting case too.
Yeah, absolutely. So Groff v. DeJoy, it was a case. This is a unique case in the sense that this was a unanimous opinion. So even the liberal justices joined in this opinion. And what that case was about, it involved a postal worker. So Groff he's an evangelical Christian, and he's probably what a lot of people call Sabbatarian. So you may have listeners probably who are Sabbatarian, some who aren't, but he really feels strongly that Sunday is the Christian Sabbath. So you should spend that day in rest and worship. And he even ordered his life accordingly. So he originally got a job with the Postal Service because he knew he wouldn't have to work on Sundays. So, so he's clearly taken steps to see that through. And then what happened is the Postal Service made a deal with Amazon to start delivering on Sundays. So he transferred to a rural post office that didn't deliver on Sundays still. Finally, the deal spread to there, and he was told, you've got to work on Sundays. Everybody has to work on Sundays. So he wouldn't do that. He was disciplined. That eventually led to him resigning. He sued under Title VII of the Civil Rights Act of 1964 to say that he had been discriminated against based on his religion, and so he actually ended up he won that case. So there is part of the way the Civil Rights Act is developed. Employers have a duty to make reasonable accommodations for religious employees. Based on their sincerely held religious beliefs. They're required to do that unless it imposes an undue hardship on the employer. And so a dispute had developed in the lower courts about what the shape of that was. It had basically developed as a de minimis standard. So if it was anything more than a de minimis cost, then the employer could refuse to accommodate the employee. And that's what the Supreme Court actually rejected. They said that that de minimis standard was not correct, and that an accommodation would have to be granted unless it resulted in a substantial increase in costs for that particular business. So again, this is probably another one of those examples. I've actually got some serious concerns about civil rights acts, period.
Right.
Like, I'm not convinced the government has the jurisdiction to force you to do business with somebody you don't want to, or to force you to employ somebody you don't want to employ. Those are a given in our landscape. And so since those are a given, this type of a requirement of an accommodation for religious employees is another example of a great victory that could help us in other areas, because it does show that this court is serious about protecting at least some view of religious liberty in a way that I wouldn't have even felt sure about for the court maybe 5 to 10 years ago.
Right.
Yeah.
That's exciting. Yeah, I'm right there with you on the Civil Rights Act, but didn't stop me from using Title VII when I was writing lots of vaccine exemption letters a couple years ago. So, I like that.
That is exactly right. Yep.
Well, Rodney, I wish we had more time to talk. Maybe I can get you back on here some other time and we can have another conversation. But thanks for being here and spending time and talking about the law with us.
Yeah, it's really been great. Thank you. Appreciate it.
All right. Thanks a lot.
All right. God bless you. Bye-bye.